Okay, I think we're going to get started. Again, thank you for attending our webinar this evening on student loans with a focus on Parent Plus borrowers and on public service loan forgiveness. My name is Nancy Neerman. I am the Assistant Director of the Education Debt Consumer Assistance Program, or EDCAP. We have been doing a series of these webinars for the ALAA, UAW, remember the number? But we've been doing a series of webinars for you. And this is just another in this series. I am typically joined by my colleague Carolina, who monitors the Q&A, but she's not here with me tonight. So in terms of housekeeping, what we're going to do is I'm going to do the presentation. If you do have questions while I'm speaking, feel free to type them into the Q&A. I will stop periodically. There's not that many of you on here, so we can just either unmute and allow people to ask questions verbally, or I'll just read the questions that you're asking. So with that, I am going to turn my video off and share my screen, and we will get started. Okay, so as I was saying, tonight's webinar is going to focus on navigating some of the issues that are going to be presented to Parent Plus borrowers going forward. And we're going to talk a little bit about some of the challenges and potential changes to PSLF coming down the road. So a little bit about the program first. If you're not familiar with our program, Education Debt Consumer Assistance Program, or EDCAP, is a program initiative of the Community Service Society of New York, or CSS. The program was created in 2019 specifically to tackle the issue of student debt. We're a New York State funded program, so we are able to offer all of these webinars and one-on-one counseling services free to anybody who resides in New York. The program was created for two reasons. Number one, because student debt is the second largest consumer debt in the country, next to mortgages. Nationally, it's a $1.7 trillion issue. In New York State, there were approximately 2.5 million borrowers with almost $100 billion worth of debt. So the sheer size of the debt really warranted a dedicated program. And then, of course, as many of you know, the system has just become incredibly difficult and confusing to navigate with all the changes during the Biden administration and now these new set of changes that are coming in as a result of the new budget bill. It's making it almost impossible for relatively intelligent individuals to just navigate through the system without some expert help. So we have a network of 10 organizations throughout the state that offers a whole range of services, and we can really kind of do anything throughout the life of a student loan, all the way from helping students fill out the FAFSA to understanding how to fund fund higher education, analyzing awards letters, and then managing your debt once you have the debt, which is what we're going to be focusing on tonight. So we're going to start with some important updates, and the most recent being the government shutdown. So what is working and what is not working or functioning now that the government has been shut down for what, like 28, 29 days? Um, the loan servicers, that would be your Mohilas, Advantages, Nelnets, Ed Financial, a CRI. The loan servicers are independent organizations. They're third-party companies that are contracted by the Department of Education to manage or administer your loans. They are not direct employees of the Department of the U.S. government. And they had appropriations for some period of time and not exactly for how long. But they are so far functioning and doing what they normally do. And that would be things like billing, collecting payments, processing certain types of applications like IDR applications, consolidations, requests for forbearance, etc. Now, if the shutdown is prolonged for some period of time, at some point it could have impact their ability to do their functions as well. But for now, and I would imagine for the foreseeable future, the one thing that is probably for sure is that you're still going to have to make the student loan payment. So don't think because the government is shut down, you've got to pass, you have to make those payments. And then the FAFSA application, if you're applying for the 2026-2027 academic year, the FAFSA application is open. New loans and Pell Grants for the current semester, that's fall of 2025, should have already been dispersed. So with the exception of some few people that maybe are trying to take those loans out late, that shouldn't be an issue. And then if you're applying for the next academic year, those loans wouldn't be dispersed until summer or fall of next year. And by that time, presumably the government will be open again. So what is impacted? Well, the Department of Education has furloughed the majority of their employees, which was already a drastically reduced staff. So they basically have furloughed 85 to 90% of their employees, and that includes the Office of the Ombudsman. And the Ombudsman is the one that typically helps resolve disputes and complaints. So that pretty much, which was already kind of challenging before the shutdown, that's pretty much ground to a halt. And then Ed is also responsible for processing certain types of discharge. So public service loan forgiveness, including the PSLF buyback applications, which we're going to talk about later. The employment certification forms you can still submit and get an updated qualifying payment count, but you just may not see the loans actually discharged for a little while because Ed has to sign off on that. They also have involvement in TPD, BDR, and other forgiveness and discharge applications and programs. So there may be delays in some of those other areas as well. The One Big Beautiful Bill Act, this is what we're going to spend most of the time talking about today. That's the new tax and spending cut bill that went into effect in July of this year, which is going to bring some major, major changes to the student loan borrowing system, the student loan system. And that includes new borrowing limits, new repayment plan options, changes to income-driven repayment forgiveness, elimination of some short-term relief programs. That's what we're going to spend most of the time talking about. Now, I do want to mention that the bill itself does not actually materially alter the PSLF program in any meaningful way. PSLF has its own statute. That statute stands. Congress, through this bill, decided not really to touch PSLF. In fact, the only mention of PSLF in the bill was to make the new RAP plan, which is the new IDR plan, eligible for PSLF. However, there is something called a negotiated rulemaking process, which is a mechanism that the Department of Education uses to make regulatory changes. And there is a process underway right now which could change or limit employer eligibility as defined under these new rules. And this was really kind of followed an executive order that the president put out earlier this year. That is not in place yet. If the rules are finalized by November 1st, which they probably will be, then this rule will go into effect in July of next year. But for now, PSLF has not changed. Again, we're going to talk a little bit more about this later. And then, of course, we have to talk about the end of the SAVE plan. We've been, sort of pondering the end of the SAVE plan now for quite a while. But just as a reminder, the SAVE plan was an income-driven repayment plan. And let me just preface all of this. When I say income-driven repayment plan or IDR, that's an umbrella term for a number of different plans, including the SAVE plan, including plans that we're going to talk about in a little while, like income-based repayment or IBR, payee, and ICR. Those are all versions of an income-driven or IDR plan. So I just want to make that clear kind of right off the bat. So the SAVE plan was introduced by the Biden administration in 2023. It would have been the cheapest option by far for the vast majority of student loan borrowers out there, which is what led about 8 million people to enroll in the plan. But it really almost never got off the ground. It was kind of in working for a few months, at which point it was facing some legal challenges. And in July of 2024, an appeals court placed an injunction on the Department of Education, preventing them from from calculating any payments under the SAVE formula or enrolling new borrowers. So anybody that was enrolled in SAVE at that time, this was July of last year, would have been placed in a forbearance. At the time, this was a non-interest bearing forbearance. And the forbearance was basically going to be on people's accounts until the courts made a ruling, which they currently still have not made a ruling. The Starting August 1st of 2025 of this year, a few months ago, the department decided to turn the interest switch back on. So loans in this forbearance are now accruing interest, whereas they were non-interest bearing for quite a long time, for actually a little more than a year. So that doesn't mean that you have to get out of the SAVE forbearance. It doesn't mean that you have to make a payment in the SAVE forbearance, but just know that if you're in it, the interest is now accruing on the account. Now, as far as we can tell, it's a little bit difficult to tell when the forbearance is now officially scheduled to end. As you may have known, they kept pushing the forbearance date back every 3 or 4 months. They would push it back another 3 or 4 months when there was no court ruling. Um, I'm seeing some really extended dates now on servicer accounts for this forbearance. I know we said here that it was pushed back until February of 2026. I'm seeing some dates going all the way out to 2028, which there's going to be something that happens with SAVE before 2028, I'm sure. But either we do not anticipate a favorable ruling from the courts, but if for some reason that happened, or they just never make a decision, this plan is going to be eliminated under the rules of the new budget bill. So basically, the SAVE plan is pretty much never going to see the light of day. If you're in it, at some point, you're probably going to have to make a decision to get out of it, particularly if you're pursuing public service loan forgiveness. All right. So let's just talk about some of the new rules and the big things that are going to be impacted. Starting with borrowing limits. So this is mostly going to take effect July 1st of 2026. Borrowing for undergraduate degrees, borrowing subsidized and unsubsidized loans, direct loans, those limits have not changed. So if you're a dependent undergraduate student, you can borrow on an annual basis anywhere from $5,500 to $7,500, depending on what year of school you're in, and up to $31,000 in aggregate for your undergraduate degree. If you're an independent undergraduate student, then you can borrow anywhere between $9,500 and $12,500 annually, up to $57,500. So nothing's changed with that. The changes really come in when you start talking about loans for graduate school. So first, you've got the direct unsubsidized loans for graduate school. Now, if you're pursuing a master's degree, the annual limit is going to be $20,500. That has not changed. The lifetime limit, however, has changed to now $100,000. That's over and above whatever you take out for your undergraduate school, and it also doesn't count any Parent Plus loans that your parents may have taken out. If you're pursuing a professional degree like law and medical degrees, the annual limit is $50,000 with a lifetime limit of $200,000. Now, you might say, well, that's a fair amount of money, although I know I'm speaking to lawyers here, and I'm sure some of you have balances that are well above $200,000. In the past, what you could do is if you didn't have enough money from the direct unsubsidized loans to cover the costs of your school, you could borrow through the Graduate Plus program. And the Graduate Plus program allowed you to borrow up to the cost of attendance. So it was the cost of attendance less any money that you receive from direct unsubsidized loans or through grants or scholarships. And what that allowed people to do was to fund their entire graduate degree within the federal system, which obviously has some big benefits to doing so, like access to income-driven repayment plans and forgiveness programs. So starting July 1st of 2026, the Graduate Plus program is going to be phased out. And what that's going to mean is that for people pursuing these more expensive degrees, $200,000 is it. That's all you're going to be able to borrow within the federal system to pursue that degree, which means that people are going to have to find other ways of funding that degree, which could, I'm sure the first place people are going to think of is private loans, which can be problematic on a number of different levels. Now, there is a grandfathering clause within for these Graduate Plus loans. If you receive a direct loan or a Graduate Plus loan prior to July 1st of 2026, you can continue borrowing within the Graduate Plus programs for up to 3 additional years to complete your current program of study. It must be your current program of study. Now you can continue borrowing in the Grad Plus loans, but you're going to have to pay back under the new rules. Now, Parent Plus loans are not going to be phased out, and Parent Plus loans do something similar to what Graduate Plus loans do for undergraduate students. So parents, under the current rules, were able to borrow up to the cost of attendance to fund their child's undergraduate school degree, and it has to be a dependent undergraduate school degree. So it's cost of attendance minus whatever the child received in student aid between student loans, grants, scholarships, that type of thing. So basically, there was essentially no limit of what you could borrow within the federal system. But now there is going to be a limit, and the annual limit is going to be $20,000 per child. The lifetime limit is going to be $65,000 per child, and this includes both parents. So, for those of you that may have children that are considering expensive private schools, you may well have to look for other sources of funding if these amounts don't cover the funding gaps for private schools. There also is a grandfathering clause here if you receive a Parent Plus loan or your child receives a direct loan before July 1st of 2026. Again, you can continue borrowing up to the cost of attendance for up to 3 years for your child to finish their program of study. But much like the graduate degrees and the graduate borrowing, you're going to have to pay the additional loans. We're going to have to pay the debt back under the new rules. And that's going to be particularly important for Parent Plus borrowers because of what the new rules do with Parent Plus borrowers, which we'll talk about in a minute. So for future student borrowers, there are basically going to be 2 options. If a student takes out any loan on or after July 1st of 2026, you're only going to have 2 options for paying back your entire debt, even if you have loans dispersed prior to July 1st of 2026. You can pay back in the standard fixed repayment plan, where the payback period is going to range from 10 to 25 years, depending on your loan balance. Standard plans the payments are based on the size of the loan, the size of the loan balance, the interest rate, and the payback period. And generally, if you pay in these plans throughout the life of the loan, you're not going to get forgiveness. Now, the standard fixed repayment plan is going to be the only plan available to new Parent Plus borrowers. And that's where it becomes really sticky for Parent Plus borrowers, because they are not going to have access to any income-driven repayment plan if they take out any loans on or after July 1st of 2026. If you're a student, you will have one option for an income-driven repayment plan, which is called the Repayment Assistance Plan, or the RAP plan. It's only going to be available to student borrowers with direct loans. So if you've got some older loans, if the only way that you would have access to the RAP plan, it would be to consolidate them, to turn them into direct loans and make them eligible for that plan, if you even wanted that. This plan is going to calculate payments at 1 to 10% of adjusted gross income. The calculation overall is quite different from the current IDR plans. It's going to reduce payments by $50 for each dependent that you claim on your tax returns. That's a less generous treatment of dependents and family size than exists with the current plans. You will have to pay a minimum of $10 under the current plans. If you have little to no income, you can get a $0 repayment plan. Under this new version, even if you have 0 income, you will have to find a way to pay $10 a month. Now, on the plus side, There will be a $50 monthly principal subsidy. So if your payments are not paying down the principal by $50, the government will do that for you. So as long as you're making that required payment, whatever it is, you should see your principal balance go down monthly, which is better than the old system where unpaid interest uh, accrued to your account every month. And even when you were paying, you saw the balances go up. So in conjunction with that, similar to the SAVE plan, if you do have unpaid interest, so if your payment does not cover the interest on the loan, which frequently can happen if your balance is high and your income is moderate, that unpaid interest will no longer be added to your account. So that just means that the loan balance will not increase. And then as a result, with the $50 principal subsidy, you would actually see the principal rate go down as well every month, as long as you're making the required payments. Spousal income can be excluded when filing separately, so that's a good thing for married borrowers. Now, and this plan is going to offer forgiveness. This is not public service loan forgiveness. It's what we call income-driven repayment forgiveness or IDR forgiveness. This is a program that allows you to forgive your debt after making anywhere from 20 to 30 years of payments. It doesn't, there's no employment requirement attached to that program. So if you didn't qualify for PSLF and you had a very high loan balance, you would be pursuing IDR forgiveness. The current plans, um, the current plans offer forgiveness after 20 or 25 years. The WRAP plan, you would have to pay for 30 years. And then this plan is eligible for PSLF. It doesn't change the amount of time it takes you to earn forgiveness through PSLF. PSLF is still a 10-year path to forgiveness. All right. So there is this new rule under the OBBBA that states that all loans have to be paid back in the same repayment plan. And this applies to loans for students and for Parent Plus borrowers. Because of this rule, if the borrower takes out any loans, any new loans on or after July 1st of 2026, all loans, even the ones that were dispersed prior to July 1st of 2026, have to be paid in either the WRAP or the standard plan if you're a student borrower, or only in the standard plan if you have Parent Plus loans. So basically, they have shut future Parent Plus borrowers out of access to income-driven repayment plans, including the WRAP plan, and which in turn makes you ineligible basically for PSLF or income-driven repayment forgiveness because you need to be in an IDR plan to achieve forgiveness in those programs. Now, the one exception is in the future, if you have loans for yourself and Parent Plus loans, you would be able to pay the loans for yourself in the WRAP plan while paying the Parent Plus loans off in the standard plan. So the loans for yourself would continue to have a path towards forgiveness through the WRAP plan. The Parent Plus loans would not. In terms of the transition, so there is this kind of tricky transition period that's going on now between now and July 1st of next year. So we're going to go through this in kind of pieces, but we're going to start with um, student borrowers. We're calling them, excuse me, legacy borrowers. These are people who are basically done borrowing. So these, if all of your loans will have been dispersed prior to July 1st of 2026, we're going to call you a legacy borrower. You're going to be able to you're going to have more options. You're going to be able to access initially three different repayment plans. So the three existing repayment plans, payee, ICR, and IBR, if you're eligible for those plans. You can access all of those plans up until July 1st of 2028. Payee and ICR are going to be eliminated on July 1st of 2028, possibly sooner. At that point, if you're enrolled into either of those plans, you would be switched to a modified version of the income-based repayment plan. The IBR plan is the only one of the existing plans that is going to survive beyond July 1st of 2028, and that is only for borrowers who have no loans that are dispersed on or after July 1st of 2026. So what is the modified IBR plan? The current IBR plan has both an income test and a payment cap. If you're if the calculation, if you're not enrolled in the IBR plan and the calculation under that plan, under the formula for that plan exceeds what you would be paying in the standard 10-year fixed repayment plan, you would not be eligible for IBR. If you were enrolled in IBR and upon recertification, you hit that threshold, that standard 10-year fixed repayment plan becomes a payment cap while you're in that plan. Now, the modified version of IBR, and this was modified in the budget bill, and it's supposed to have been available immediately upon the bill's signing, but we'll talk about that in a minute. But the modification is that there will be no income test going forward, but the payment cap will remain. And what that means is that anybody with a direct or FFEL loan will be eligible for the IBR plan, including Parent Plus borrowers, by the way. Some Parent Plus borrowers, some legacy Parent Plus borrowers, and we'll talk more about that in a minute. But modified version of the plan means that the direct and FFEL borrowers can enroll in the plan and can actually enroll at the payment cap. The problem with this is that the systems need to be upgraded. The online IDR applications, the servicer systems all need to be upgraded to account for these modifications, and that hasn't happened yet. And it may not happen for several months. The department said that they were targeting winter as a time to get the fix in the systems. But with the government shutdown, that timetable could be pushed back. So, but we should anticipate, though, that hopefully within the coming months, this will be adjusted. Right now, there are some borrowers that should be eligible for IBR that can't get in because of this system issue. It's not because they're not eligible for it. The systems just won't allow them to do it. Now, there's two different versions of the IBR plan, and people will continue to qualify based on when their loans were dispersed. If you have any loans that were dispersed before July 1st of 2014, you would be eligible for the older version of IBR, which calculates payments at 15% of discretionary income and offers forgiveness after 25 years. If your first loans were dispersed on or after July 1st of 2014, the payments calculated at 10% of discretionary income, balances are forgiven after 20 years. So legacy borrowers will continue to have access to these IBR plans based on whenever their loans were dispersed. You will also have access to the new WRAP plan when that becomes available, and the new version of the standard plan when that becomes available. But if you're pursuing forgiveness, you probably want to be looking at the WRAP plan. New student borrowers. So if you take out any loans, or if any loans are dispersed on or after July 1st of 2026, that basically means that you will only have access, this is for student borrowers, to standard plan and the repayment assistance plan. And because of this rule that says you must pay all your loans back in the same repayment plan, that means all of your debt is going to have only access to those two plans. And I should also mention that if you consolidate older loans on or after July 1st of 2026, that is like getting issued a new loan, and that new consolidation loan will be subject to the new rules and limited to these two different repayment plans. Now let's talk about how this impacts parent borrowers. Again, we're looking at existing or legacy parent borrowers. So that means all your loans are dispersed prior to July 1st of 2026. You don't need to borrow any additional amounts after that. In order for you to retain access to any income-driven repayment plan and therefore access to forgiveness programs, you must fully consolidate your loans before July 1st of 2026. So this doesn't mean that you can wait until June 30th and submit the application. You have to submit the application, and then the whole thing has to be processed, the new loans dispersed before July 1st of 2026, in order for you to continue to be eligible for income-driven repayment plans. And because remember, like once you have a loan that's dispersed on or after July 1st of 2026, you're a new borrower. That means new borrowers can only make payments in the standard repayment plans. Other recent guidance that just came out from the Department of Education says that borrowers who do this must consolidate their loans, enroll in the ICR plan first, make at least one payment in ICR before transitioning to IBR. Because remember, ICR is going to be phased out on July 1st of 2028. If you need to continue to make payments beyond that date, you're going to have to do it in the IBR plan if you want an income-driven repayment plan. Because even if your loans are consolidated, if they're Parent Plus loans, they're not going to have access to the WRAP plan. So the loans will be transitioned to one of the modified IBR plans if they're not already enrolled by that date. Now, just to go back in terms of the critical dates here, the main critical thing coming up in the next sort of 6 to 7 months is if you have unconsolidated Parent Plus loans, you've got to get those loans consolidated before July 1st of 2026 to continue to earn credit towards or to continue to access the IDR plans. If you are, sorry, I lost my train of thought for a second. What you do not have to worry about, at least in the immediate sense, is enrolling in ICR and making that ICR payment before switching to IBR. If you want, I mean, obviously, if you want to do that and you want to get into IBR as fast as possible, you want to do that as quickly as you possibly can, but you don't have to do that by July 1st of 2026. You just have to do it before the ICR plan is phased out in 2028. So there's still plenty of time for that part of the requirement. But the key thing and the critical thing is to make sure that the loans are consolidated and dispersed prior to July 1st of 2026. And once again, if you take out any new loans on or after July 1st of 2026, any new Parent Plus loans, those loans can only be paid back in the standard repayment plan, even if consolidated. So that will subject your entire Parent Plus balance to only the standard plan as an option. This is just an illustration it's a comparison of the new WRAP plan compared to the IBR plans. These are for the legacy borrowers that still have access to these plans going forward. For the purposes of calculating the payment cap on this chart, I assumed a loan balance of about $85,500 and an interest rate of 6.58%, which sets the payment cap at $974. So this person would never have to pay more than $974 in an IBR plan. And then in terms of family size and dependents, we assumed a family size of 2 for IBR and number of dependents for WRAP as 1. And what you can see from this chart is that in comparison to the older version of WRAP, of IBR, excuse me, the WRAP plan compares pretty favorably up to the point where the payment cap starts to kick in for that IBR plan, because the WRAP plan does not have a payment cap. And generally speaking, I've kind of looked at this at these higher income levels, the WRAP plan becomes a more expensive plan, and certainly more expensive than the newer version of IBR. So people will have to keep that in mind. And again, if you're pursuing public service loan forgiveness, you just want to pick the cheapest option. If it happens to be WRAP and you're eligible for it, by all means, enroll in WRAP. The new version of the standard plans under the current system, there are a number of different ways you can pay back in a standard plan. There is a 10-year plan. There's an extended version if you qualify that offers you a 25-year payback period. If you consolidate your loans, you could pay back anywhere between 10 and 30 years, depending on the balance. And there are graduated versions of these plans where payments start off low but go up every couple of years. That's all going away starting July 1st of 2026. There's going to be one standard plan. It's going to be a fixed plan. Payback periods are 10 to 25 years. So the maximum payback period is 25 years compared to 30 years now. And it all depends on your loan balance. And I just gave you some examples of what the payment might look like in these various standard plans. Some of the other changes that are going to be implemented. So for loans that are dispersed on or after July 1st of 2027, those loans will not be eligible for economic hardship or unemployment deferments. Those deferment options are going away for loans dispersed on or after July 1st of 2027. If you have loans that were dispersed prior to that date, you can still access deferments and forbearance under the existing rules, but not for loans that are dispersed on or after that date. I would just make a point here that if you're eligible for an economic hardship or unemployment deferment under the current rules, you probably are still going to be eligible for a very low um, repayment option under the new WRAP plan as well. It will not be zero, but it would be, at a minimum $10. Um, the other thing is that you will only, for loans, also loans with the same disbursement dates, you're only going to be able to take a forbearance for 9 months during any 24-month period. And I know this is where it's going to get a little bit tricky for some people because people have relied on these general forbearances. Under the current rules, you can get general forbearance for up to 36 months over the life of the loan. That's going to change, and people will only be able to stay in these forbearances for about 9 months at a time. Starting July 1st of 2027, if you are defaulted, you will get two chances at loan rehabilitation, which is one of the ways of getting yourself out of default. It's a process by which you make 9 payments over a 10-month period. And then borrower defense to repayment and closed school discharge. These are two discharges, particularly BDR, which have been very difficult to achieve generally over the past sort of 10, 12 years. The Biden administration created some rules that would have made it easier for people to get discharges, particularly in BDR. And those rules have been now, as a result of this bill, put on hiatus. They won't be implemented until 2035. And those particular rules are also being challenged in the courts right now. Now, there are older rules that are still in place for both programs, but it's harder under the older rules to get your loans discharged, particularly for borrower defense to repayment. And I know that some of our clients have been told by the Department of Education before they shut down that BDR applications could take 3 to 5 years to process at this point. So we're not saying you should never submit a BDR application. This is if you feel that your school was guilty of some kind of fraudulent activity, but you might want to reach out for some assistance in doing so. And you might not want to lock yourself up in a forbearance for many years, waiting for it to happen when you don't know what the outcome is going to be, and you could be pursuing other options in the meantime. Okay, I'm going to stop there. Oops. And see if there are, let me just see if I can get to the Q&A here. Okay. Will PSLF forgive interest accrued while loans are in forbearance? I'm waiting for my IDR application to be processed. Yes, PSLF forgives everything. Everything that's there at the end of the once you reach your 120 qualifying payments will be forgiven. And the best feature, one of the key features and a great feature of PSLF is that forgiven balances are not taxed at the federal level, and they're not taxed in New York State either. So you might even, if you hear or read anything about student loan forgiveness being taxable starting in 2026, that applies to that income-driven repayment forgiveness, that long-term forgiveness. If you don't have a PSLF job, it does not apply to PSLF. That's its own statute. That statute has not been changed. Forgiven balances are not taxable at the federal level. Okay. Sorry, it's a little bit difficult for me to. Okay, is there anybody else that has a question? If you do, just feel free to raise your hand. I'm happy to unmute you and you can just ask me the question now. Okay, I don't see any hands, so we're going to continue on with the presentation. So I wanted to talk for a minute about the IDR account adjustment, and this is presumably maybe a little bit less important for you folks, as I'm assuming that most of you are pursuing public service loan forgiveness. But you may remember that during the Biden administration, they implemented this program called the IDR account adjustment, which was a one-time account revision that gave borrowers retroactive credit towards IDR forgiveness, which, by the way, can be turned into credit for PSLF by filing those PSLF certification forms based on a set of relaxed criteria. Now, there was a tracker that was up on an IDR forgiveness tracker that was up on borrowers' accounts earlier this year. That was put there by the Biden administration in January and then taken down, I think, in February or early March. But the information, if you're still interested, is actually in the system. And the way you can access that information is by logging into federal student aid. You want to open up a separate tab in the same browser that you've got your studentaid.gov account opened. And then when you get this deck, you will plug this link into that tab, and it's going to come up with this text file. If you have the ability to click the pretty print button, you want to do that because that's going to make it look, this is the pretty version. It looks pretty ugly if you don't click the pretty print box and difficult to read, but it's going to give you some numbers on what your qualifying payment count is under that IDR account adjustment. Just remember, if you ever wind up pursuing IDR forgiveness instead of PSLF, any qualifying payments that you accumulated in these plans can be transferred to the IBR plan and eventually to the RAP plan. Okay, so now we're going to talk more about PSLF. As you probably all know, but I'll just give you a quick refresher. PSLF forgives balances after making 120 qualifying monthly payments. So that's 10 years worth of qualifying payments. And a qualifying payment would be an on-time payment made in full on or after October 1st of 2007, because that's when the program started. And anything that you did before then will not count towards PSLF. You must have direct loans. You must be in an IDR plan, or payments in a standard 10-year fixed repayment plan count as well. But remember, if you stay in a 10-year standard fixed repayment plan for the life of the loan, you pay it all off in 10 years. So there would be nothing left to forgive. So even if you were making some payments in the standard 10-year fixed plan, you will eventually have to switch to an IDR plan. And then the employment requirements, you must be working an average of 30 hours per week for a qualifying employer, which is a nonprofit or a government. The payments do not have to be consecutive. Just remember that you must meet the employment requirements at the time you submit that final forgiveness application. So if you're going to be at a 120 qualifying payments next month, you don't want to quit your job until you file the application requesting forgiveness that's going to get them, and the application that's going to get you to 120 qualifying payments. And then, as I mentioned earlier, the balances are not taxable, forgiven balances. The buyback, there's been a lot of talk about the buyback. And I'm sure a lot of you, most of you have probably heard about the buyback, but let me go into it in a little bit more detail. So the buyback was part of a new regulation that was introduced in 2023. But because of the IDR account adjustment, which basically gave you a lot of retroactive credit for periods that you were in disqualifying statuses, the buyback really didn't become necessary until more recently. And it also, at the time that they created the buyback, I don't think anybody had anticipated the save forbearance, which is maybe one of the reasons why the buyback has now become such a bear to process. What the buyback allows you to do is purchase months that you spent in a disqualifying payment status under the following circumstances. So you must have 120 qualifying months of employment on record, not qualifying payments. If you had 120 qualifying payments, you wouldn't need to do the buyback. So you just must have 120 qualifying months of employment on record. So you may have to update your employment by submitting the PSLF certification form to get there. And then the months that you buy back has to bring you to 120 qualifying payments. So that means that not everybody is necessarily eligible to do this right now. Just as an example, if you, let's say, are at your 120 qualifying months of employment and you've got 110 qualifying payments already on record, you would need to be able to buy back at least 10 payments to get you to 120. If you only had 5 payments to buy back, you wouldn't be eligible for the buyback right now. You cannot purchase months prior to consolidation, and you can't purchase months spent in a school deferment, a grace period, or in default. And then the question is, how do they calculate the payments for the buyback? So there's a formula or a series of explanations on federal student aid that say how they do this. And it's partially dependent on how many months you're buying back, whether you're buying back fewer than 12 months or more than 12 months. It may entail looking at the IDR plan that you were enrolled in just prior to the disqualifying status and what the IDR plan was when you came out of the disqualifying status and taking the lower of the two. They may, if you span more than one tax year, request certain tax information to update and calculate the payment. And for some months that are being bought back under the save forbearance, they may be using the old revised pay-as-you-earn calculation to determine what those payments are, because remember, they're barred from using the save formula to calculate any payments. So we haven't actually seen any buyback applications that have been processed, particularly for borrowers who were trying to buy back months in the SAVE program. So we can't say for sure, but this is basically my understanding of how how they're going to calculate the payment. And just understand when you're ready to do it, you can submit the application. It's really easy to do it. You just you go through the PSLF reconciliation portal, which when you get this deck, you'll have that, and then you simply click the PSLF buyback option, and then you wait. And you could be waiting a really long time because the PSLF buyback application apparently is it's a very labor intensive application to review, and it is being reviewed by ed employees. And prior to the shutdown, we were told that there were basically literally a handful of people that were looking at these things. And as of a status report that was given in August, they had processed in August 5,600 applications, but the backlog, which keeps growing every month, had grown to 74,500 applications. And that indicates that the amount of time it may take them to clear the backlog could be well over a year, particularly as the shutdown, I'm sure, is just exacerbating this whole situation. So all this is to say, if you are eligible for the buyback, you should absolutely submit it. There's no downside to submitting it. It doesn't commit you to anything. Once you do get the thing processed, they're going to send you a letter. It's essentially a proposal that says, you will need to pay X amount of dollars to buy back all these months that you want to buy back, and you have to do that within a 90-month period. 90-day period, not 90 months. So if that is something that you cannot do, you simply just reject it, and then you go on making payments, monthly payments, and accumulating credit that way. But so there's no downside to submitting it. It's just that you may not want to rely solely on the buyback to get you to loan forgiveness, particularly if you're 4 or 5 months away. You're probably going to be able to make those payments in a different IDR plan faster than you will get a PSLF buyback application back. One of the things that you can do is continue to submit your employment certification forms. These are the forms that verify that you've met the employment requirements for PSLF. You need to have at least one application on file for every qualifying employer that you've had since October 1st of 2007 or later. And you want to submit the forms annually. There's no deadline for submitting the forms, but the form has to be on file for you to get an official qualifying payment count. So submit them annually or whenever you change jobs. If you've never submitted them in the past, you can still submit them and get caught up, but then going forward, submit them annually. The best way by far right now to submit these things is by using the PSLF help tool from your studentaid.gov account and request an electronic signature from your employer. We've seen those applications get processed literally within days, where the qualifying payment count is getting updated. Now, as I said before, if you get updated to 120 qualifying payments because you submit these forms. Right now, because of the shutdown, you may have to wait a little bit longer to get the loans actually discharged, but the count will update fairly quickly. Anything submitted with any form submitted with a manual signature is going to delay, could take literally months to get the forms processed. I wanted to talk a little bit also about consolidation and the consolidation impact on PSLF credit. So the same rules that introduced the buyback in 2023 also introduced or allowed borrowers to consolidate loans that have PSLF qualifying payment credit and receive what's called weighted average retroactive credit post consolidation. And I'm going to give you an example of that in a minute. The key thing here is that you need to get an updated qualifying payment count on all of your underlying loans before you do the consolidation. So you want to submit a PSLF certification form. If you haven't done one recently, get a qualifying payment count update on all of your loans. Another good reason to do it with an electronic signature because you'll get that count really quickly. And then you want to screenshot, even though that count should remain in your PSLF tracker, you want to screenshot it anyway so that you'll have some kind of proof post-consolidation of what the post-consolidation credit should look like. If you include any non-direct loans which are not eligible for PSLF, like FEL or Perkins loans in the consolidation, they're going to be assigned a PSLF qualifying payment credit of 0 for the purposes of the weighted average calculation. And remember, Parent Plus loans are eligible for this as well. Parent Plus loans do get credit towards PSLF, but they must be consolidated in order to eventually enroll in an IDR plan to achieve that forgiveness. Consolidated loans dispersed on or after July 1st of 2026, again, will be considered new loans and will be subjected to the new repayment rules, which, remember, again, if you're a Parent Plus borrower, that means you can only pay back in a standard plan and you've effectively lost your access to IDR and forgiveness. So this is how the PSLF weighted average credit works. And we actually have a calculator on our website. I provided a link to it here. So if you want to play around with this, you can plug your loans in and their respective qualifying payment credits. And then you can look at the pre and post consolidation results. This box down here at the bottom is going to compare one to the other and tell you how many potential months of payments you might save by doing this consolidation. So in this example, we've got two loans, both $50,000. One has 25 qualifying payments, the other has 75. If they don't consolidate the loans, then they're going to have to pay back for 95 months to eliminate their entire debt. So basically, they're going to have to pay back as long as they have to pay on the loans with the lowest amount of qualifying payment credit. Post-consolidation, they're going to have $100,000 worth of debt, but they're now going to have 50 months of qualifying payments altogether, which means that they're only going to have to pay back 70 months to eliminate the entire debt. So this individual would have saved a little more than 2 years by doing this consolidation. If you're not sure about whether or not you want to do this, give us a call, particularly if you have Parent Plus loans. We want to make sure that you do this the right way. The rules are in place, and we know that it's worked for some people. We also have had a couple of people that have run into problems with this, where they consolidated and did not get the retroactive credit post the consolidation. So then that becomes a complaint. So you want to make sure, if you're going to do it, you want to make sure it's really worth your while. If you go through this exercise and it says you're going to save 2 or 3 months, it's not worth doing it, truthfully. It's only if you're kind of getting into the years that it kind of makes sense. Okay, so now we're going to talk about the PSLF and the negotiated rulemaking. So you may have been familiar with the Trump administration's executive order earlier this year that basically said that it was going to redefine what a qualifying employer was and apply their own kind of interpretation of employers that participate in activities that they claim to have an illegal purpose. So the negotiated rulemaking process is the way that they're going to try to implement this rule. The rulemaking is over. They're now just finalizing the rule itself, and that has to be published in the Federal Register, I believe, on either November 1st or November 4th. I'm not sure of the exact date. So sometime in the next week or so, it needs to be published in order for them to implement the rule on July 1st of 2026. So what is an illegal purpose as defined by these rules? And by the way, it is the Secretary of Education that would be tasked with determining whether these rules fit the description of illegal purposes. And she does that on the basis of looking at it on a preponderance of the evidence type basis. So it's kind of unprecedented that the Secretary of Education would be the one that would have this kind of discretion over legal matters that, one could argue that whether or not they're qualified to do that. But this is how they're defining these illegal purposes. For anybody that may be aiding or abetting violations of the federal immigration laws. And I know that there are a lot of legal aid organizations that are concerned that if their organization helps illegal immigrants, does that mean that they're aiding or abetting the violations of these laws? Organizations that support terrorism. I think this is kind of geared to people that maybe are pro-Palestinian, pro-Gaza. Engaging in chemical and surgical castration of children. This is gender affirming care. And of course, the question there is if you work for a hospital that where a small subset of their patients are getting gender affirming care, does that mean that the entire hospital loses access to loses their qualifying employer status? Engaging in a pattern of aiding and abetting illegal discrimination, that's DEI. Like I said, if enacted, the new rules would go into effect on July 1st of 2026. Payments towards public service loan forgiveness will not qualify for months subsequent to a determination that the employer engaged in these activities. And then the qualifying status would be suspended for 10 years unless the organization, or this could be applied to a government as well, agrees to some kind of a corrective action plan, and the bar would have no right to appeal. So obviously, this is a very concerning potential development. What I can tell you is there is every possibility out there that if this rule does go into effect, it's going to be challenged. And then we'll have to kind of take it from there. Like I said earlier, the Congress decided not to change the statute. And these rules seem to run in contrary to the actual statute. So we'll have to see what happens. But for the time being, PSLF remains in place under the current rules. All right, very quickly, some guidance for borrowers going forward. So Parent Plus, I mean, I've said it kind of all throughout this presentation. If you are a Parent Plus borrower, you really want to pay attention to this and reach out to us for a one-on-one. So we'll help you and make sure that you're set up. But the key thing to remember is if your loans are not consolidated and if you're not going to be taking out any additional debt after July 1st of 2026, get those loans consolidated, start the application no later than April 1st of 2026 so that the new dispersed loan is dispersed prior to July 1st of 2026. Then at some point you will need to enroll in the ICR plan and then eventually transition to the IBR plan sooner if that's a cheaper plan for you, which it is for a lot of people. Or if it's not, you can wait until ICR is phased out on July 1st of 2028. Again, the payment portion of this doesn't have to be done by July 1st of 2026. You just need to make sure that you're consolidated. Because any Parent Plus loans, if you take out any loans dispersed on or after July 1st of 2026, no access to RAP, no access to modified IBR, and thus no path towards forgiveness, basically. If you plan to take additional loans, well, fall 2025 loans probably were already dispersed. Or if you're taking loans in the spring and then you're going to be done, you want to consolidate the loans immediately upon the disbursement of the spring semester. Those loans generally get dispersed in January. So as soon as you can do it after that, you want to do it. If you have defaulted Parent Plus loans, now's the time to think about getting those things consolidated because that'll kill two birds with one stone. It will get you consolidated and positioned for new IDR plans. It can also get you out of the default. Now, if you're planning to take additional Parent Plus loans on or after July 1st of 2026, if that was part of your original plan, um, if you do that, you're going to have to pay your debt back, all the debt back in a standard plan. So if your original plan was you were going to continue to borrow, but you wanted to pursue PSLF, you've got some strategic decisions to make. For instance, if you, let's say you are 3 years into Parent Plus borrowing and your child has one more year to go, um, you might consider another source of funding for that final year so that you don't jeopardize your access to the forgiveness programs on your existing federal student loan debt. And that might be a private loan, which isn't great, but if it's going to allow, the bulk of your debt to continue to pursue forgiveness, it may well be worth it. Again, you can reach out to us and we can walk you through some of these scenarios and try to come up with a plan that makes sense. If your goal is to repay your loans in full, then these new rules probably really haven't affected you all that much. You can pursue this approach in any repayment plan, whether it's a standard, extended, or even an IDR plan. If this is your plan to just pay the loans off, you want to pay as aggressively as possible because the sooner you pay the loans off, the less you pay in interest over the life of the loan. If you're pursuing that long-term forgiveness, which I'm guessing most of you are not doing here, you want to enroll in one of the three income-driven repayment plans that are available right now, IBR, Payee, and ICR, whichever one is going to be cheapest for you. If you are going to be eligible for forgiveness in ICR or Payee before those plans are phased out in July of 2028, then you can remain in those plans. And a recent development is that the government says they will now forgive loans in the IDRF program if you're in Payee and ICR. Previously, they said you had to switch to IBR, but now you can be in either of those three plans. But basically, if you're going to have to be paying beyond July of 2028, and this really applies to PSLF as well, look at IBR first, because that's the one plan that's going to survive beyond July 1st of 2028, as long as you don't take out any new loans. And then the qualifying payment credit for IDR forgiveness that you've earned in SAVE, Payee, and ICR will transition to IBR or WRAP if you need to pay beyond July 1st of 2028. Now, one little cautionary note here: if you're consolidating loans and you're pursuing IDR forgiveness, you may lose retroactive credit that you accumulated during the IDR account adjustment at this point. In the future, you may not, but right now you may. So before consolidating at this point, you probably want to reach out for any reason you want to reach out for some kind of advice. If you're pursuing PSLF, again, if you're enrolled in any of these plans right now that you're able to make payments in, stay in them, continue to make the payments. They'll continue to earn credit. If you're in the SAVE forbearance and you can afford some of these other plans, you want to switch right now because all payments in all these plans, with the exception of the SAVE forbearance, are going to earn credit towards PSLF, all of the income-driven repayment plans. And then submit the buyback application if you're eligible, but you might not want to rely solely on that. You might want to do that and switch your plan, start making payments, and see which strategy gets you to PSLF faster. For those borrowers that may be considering the WRAP plan when it's available, which would not be until July of next year probably, the WRAP plan may be cheaper than the existing repayment plans. It may not be. It depends on your circumstances. Existing student loan borrowers can switch to the WRAP plan when it becomes available. If you're pursuing PSLF, you just want to pick the cheapest plan because remember, PSLF is always going to be a 10-year path to forgiveness. That's not going to change regardless of what plan you're in. So you just want to make a payment in that plan until you get forgiveness. If you're pursuing that longer term forgiveness, even though the WRAP plan may be cheaper than IBR, remember that in the path to forgiveness, that the longer term forgiveness in WRAP is 30 years compared to 20 or 25 years in IBR. So you could be paying 5 or 10 years longer, which needs to be a consideration. I think I saw somebody with a hand raised a second ago. If you want to, Maybelline, if you want to unmute yourself and ask your question. Let's see. Are you able to unmute yourself?
Okay. Yeah, can you hear me now?
Yes, I can. Yes.
Okay, so for the regarding the buyback, the employer has to be a qualifying employer also?
Oh, yes. Any credit for PSLF has to come from a qualifying employer. So if you don't have a qualifying employer, you're not going to be able to earn any credit towards PSLF, whether it's through the buyback um, or through the regular payments. But that's why they say that in order to do the buyback, you have to have 120 qualifying months of employment on record. So when you submit those employment certification forms, it will update your employment even if it doesn't update your qualifying payment count. So once you've got enough employment on record, you're eligible to do the buyback.
Okay, all right. Thank you.
You're welcome. Anybody else? Okay. I know we did schedule this till 7:15. Oh, Allison? Let me go ahead, Allison, if you want to unmute yourself.
Yes, hi. I put
Hi.
a question in the question area, but I'm trying to figure out, I've been told that I have to start paying in November. It's at the rate that I was assessed back in 2020. But I'm going to pay it, but I also have 120 qualifying pay periods under a qualified employer, and I have a pending buyback. So I'm a little
Well,
confused. I'm
I'm a
sort
little
of
confused as well. I mean, why are they saying what repayment plan are you in that you have to start paying in November?
save.
Okay, so then you don't have to pay in November if you're in the save plan. I don't know why they're you know what? There's been a lot of notifications. Did you receive a notice in the mail or an email about this?
Both.
Okay. Yeah, there's been a lot of really confusing notifications that have gone out that basically tell you what your payment might look like, and it seems to be triggered every time they switch uh, the forbearance date on the save plan. It triggers these notices that confuse people to no end. And I don't think that that notice is saying that you're going to have to make a payment. It's probably one of these notices that's just super confusing. You Who's your servicer?
Mohila.
You want to log into your Mohila account and then click on the loan details and click into one of the loans that you have. And right at the top, it's going to tell you what your loan status is, whether you're in repayment or in forbearance. And then it will tell you when that forbearance is going to end. Um, just double check. If it says the loan status is in forbearance, you do not have to make a payment. If you want one of our counselors to look at the notices because you're concerned about that, then contact us and we'll just schedule an appointment just to make sure. But um, you're not gonna, if you're in the save forbearance, you do not need to make a payment in November.
All right. So the other question I have is related to, so I'm in save forbearance.
Right.
Now, part of the 120 pay periods were in that forbearance period. Does
That's
that mean that those aren't counted towards my qualifying
so
periods?
correct. So the time that you spent in the save forbearance does not count towards forgiveness, but that's what the buyback is for.
Right. Okay.
The buyback application would allow you to buy all those months back. Um, and I'm assuming that you don't have 120 qualifying payments, right? You have less than that
I
on
have
your,
113
right.
qualifying payments.
Okay, so you need seven. in the buyback to get you to 120. But what I was saying before about this strategy is it could take a really long time to process that buyback application, right?
Right.
So if you're 7 payments away, you might want to consider switching out of Save right now into a different repayment plan, and then just starting to make those payments and see which one gets you to faster to PSLF.
Okay, so, and I don't want to totally take up, but okay, so the question I have is I already put in an application to transfer out of Save,
Right.
right? But I haven't heard anything. I was directed to put in a new application
Yeah.
because the old application seemed to have gotten lost.
How
So
old was it? When did you, how old?
I put it in April, and then I put it in again in September.
Oh, well, if you put one in September, I don't know that you would need to put one in again.
No, I don't think so. But if I start paying in November at the lower rate, will
No.
that qualify as a qualifying payment towards my?
No, don't do, you
Oh,
don't want to make a payment until your loan status has been switched to repayment.
Okay.
If you make a payment while you're in forbearance, it will not count.
All right.
I know. So, but
And then they tell you to go right, and then you go right, and they tell you to
I
go straight.
totally
So,
get it.
yeah,
I
okay.
really, I
All right.
get it. But, and again, feel free to reach out to us if you want a one-on-one. And
Yeah, I've talked to you guys a couple times. So
yeah, I know.
Thank
Well,
you.
we can only do, we don't control the Department of Education.
No, you're not miracle workers, but you're
No.
close. You're close. Thank you.
Okay, you know what? I think we're pretty much at time. I did have some information here on delinquency and default. Hopefully there aren't too many of you that are in delinquency or default, so I'm going to just let you kind of review this. If you have any questions about that, or if you are in default, please do give us a call, and we'll work with you to get out. So with that, and when you get the deck, by the way, you will have our contact information. So there's different ways to contact us. You can schedule an appointment online. You can call us. You can email us. And all this information will be there when you get the deck, and you'll have access to the recording as well. So I'm just going to stop and see if there are any other questions. Anybody want to raise your hand? Let me just, yeah, I think I addressed everybody's questions in the Q&A. Okay, I don't see any hands raised, so thank you again. I know it was a tremendous amount of information. I hope this helped you. And like I said, feel free to reach out to us if you need individual help. Have a great evening, everyone.